For the disruption. We received a, sorry, I'm just waiting. Again, we apologize for the disruption. We were notified by the San Francisco Police Department that we needed to adjourn the meeting. There was apparently a security threat that has been found not to be credible. So that's why we're back, and that's also the reason why we initially adjourned. So we are back in session. Mr. Mayor, I caution you that you're still under oath. I believe when we left off, there was a question pending. Mr. Kopp, would you like the court reporter to reread the question, or would you like to ask a question?
I have no idea what the question was, so it'd be great if we could get it read back. Because that's never happened to me before.
I don't think you're alone in that regard.
Okay, and would you agree with me that one of the things that is expected of elected officials is for them to be honest and forthright when dealing with not only their constituents, but with other elected officials?
Thank you. And there was an answer?
No, there was no answer.
Then, Mr. Mayor, if I could ask you to answer that question.
Yes.
Okay. And when you became mayor, you told everybody you were not going to run for election. You were going to be a caretaker mayor, and you were then going to leave office, correct?
Objection, relevance, argumentative.
Sustained.
Well, may I be heard on this?
You may.
If one of the things that is expected of public officials is honesty to constituents and other elected officials, and if that falls below the level of decency, I think that's relevant to this inquiry if this particular witness has fallen below that level.
My view is that the mayor's conduct is not at issue before us as far as whether or not his conduct fell below the standard required by 1505.
Okay.
That's why I think it's irrelevant.
Okay. Now, Mr. Mayor, you've given some public statements about the reasons that you filed these charges, right?
Yes.
Okay, and you've spoken to some reporters, right?
Yes.
And you have told at least one reporter that the reason why you think the sheriff should be removed is because he beat his wife, right?
Yes.
Okay. Upon which facts do you base that assertion?
The court records.
Okay.
And his admission of guilt.
Well, the sheriff has admitted that he grabbed his wife's arm in an argument and left a bruise, right?
He admitted to domestic violence.
Okay.
And he caused the bruises on his wife.
Okay. Do you see a distinction between grabbing someone hard enough to leave a bruise and striking them, perhaps with a fist?
I believe he caused bodily harm to his wife, and that's what the basis of the facts are in his plea.
Okay. And to you, that's synonymous with beating his wife?
Yes.
All right. Now, do you think that it falls below the standards of decency and right action expected of elected officials if you have an affair with a subordinate who happens to be married to one of your good friends?
Relevance. Objection, relevance.
Sustained.
Does it fall below the standard of decency and right conduct expected of public officials to strike your spouse with a glass?
Objection, relevance, calls for a legal conclusion.
That one I'll overrule.
I'm not sure I understand the question.
Please, again, instruct the sheriffs. If we hear any outbursts, I want that person removed. Thank you. Yes, I'm speaking to you. If I want you to be observing the crowd, if anyone makes an outburst, and I understand, public, trust me, I understand that there's an urge to have a physical reaction, but we really do need to keep silent. So please remove them if there's an outburst. I apologize, Mr. Kopp.
No, that's fine. Let me see if I can explain. You're aware that there were allegations that the fire chief struck her spouse with a glass, right?
I read some allegations in the newspapers.
Okay. Were any steps taken to remove her from office?
I don't know.
Okay. Would that fall below your definition of the standard of decency and right action?
Objection calls for legal conclusion.
Overruled.
I don't know what you mean by that, because I don't know all the circumstances around that, and I don't believe I was mayor at the time.
Okay. Now, in your initial filing of written charges of official misconduct, there was no mention of the sheriff doing something improper with the way that his firearms were turned over to law enforcement, correct?
Objection, foundation.
Overruled.
There is declarations from the police department that indicated that there was less than full compliance with the orders of the court.
And you didn't make note of that in your original written charges of official misconduct, right?
Objection, foundation assumes that the mayor wrote those charges.
Okay, well, why don't you lay the foundation about
Sure.
what was in the charges? Sustained.
You originally caused written charges of official misconduct to be filed against the sheriff, correct?
Yes.
Now, presumably you read those before you filed them, right?
Yes.
Okay. So you know what was in the original written charges, right?
Yes.
And there's nothing in the original written charges about the sheriff doing anything improper with relation to the getting of his firearms into police custody, right?
I don't recall originally, yes.
Okay. And in fact, you don't believe that to be a sufficient basis to remove the sheriff from elective office, right?
Objection, argumentative, lacks foundation.
Overruled.
Are you speaking to that just being the sole charge?
Yes. If that's the sole charge, do you believe that that is sufficient to remove an elected official from office?
Irrelevant, objection.
Overruled.
In and of itself, I do not.
As a matter of fact, in your filing of written charges, you have confined yourself to the incident between the sheriff and his wife on December 31st, as well as allegations that the sheriff may have been involved in attempts to dissuade witnesses, right?
Objection. Do you have a document you'd like to put in front of
No,
the
I'd like to
mayor
ask the witness a
sorry.
question.
I'm sorry, do you have a document that I didn't hear?
that you could put in front of the mayor?
Okay, what is the basis of the objection, the legal basis?
I think he's misrepresenting the document, and I think it would help the witness to be able to see the document rather than be quizzed by memory.
I
don't have one word for that, sorry.
I think the question was unclear. I would ask that you rephrase it.
Okay. Let me ask you about your claim that the sheriff engaged in witness dissuasion. You're familiar with that claim, right?
Yes.
And in fact, in the original written charges of misconduct, the only thing that you claimed was that he may have been involved in witness dissuasion, correct?
I'm not familiar, I can't remember the exact wording, but I understand the issue, yes.
Okay. In the amended charges, you now say that he did engage in witness dissuasion.
Yes.
All right. And what is the information that you learned since the original filing of the charges and the amended charges that caused you to make that definitive assertion?
Objection, attorney-client privilege, and assumes facts not in evidence.
Can I have the question read back?
All right, and what is the information that you learned since the original filing of the charges and the amended charges that caused you to make that definitive assertion?
I'll hear argument
Well,
on the attorney-client privilege.
I would limit it to information he got from sources other than his lawyers.
With that stipulation, the objection is overruled.
So just to be Could Mr. Kopp restate the question with the limitation,
Yeah,
please?
let me see if I can re-ask it. Without telling us anything that you learned from your lawyers, can you explain what is the basis for your assertion that the sheriff engaged in witness dissuasion?
The review further of the declarations or the statements that were reflective of the videotape and the declarations of the particular witness, Ivory Madison.
And is it your assertion that Sheriff Mirkarimi somehow dissuaded Ivory Madison from speaking with the police?
I believe that he was part of the effort to not have people talk to the police department,
Okay.
including his wife.
Okay. And what do you base that belief on?
The declarations, not declarations, but the transliteration of the videotape.
And when you say the videotape, you're talking about the 1-minute videotape that Ms. Lopez made with Ms. Madison?
Yes.
Okay. Are there any other facts that you base that assertion on?
Objection, attorney-client privilege.
Excluding conversations with your counsel.
Conversations with your counsel.
With that limitation, the objection is overruled.
The declarations of Ivory Madison.
All right. Now, you have stated in your declaration that one of the reasons that was significant to you that this was official misconduct is because a law enforcement officer must follow the law and enforce it, but Sheriff Mirkarimi pled guilty and was convicted of a crime. Is that right?
Yes.
Okay. Is it your belief that any time a law enforcement officer is convicted of a crime, that constitutes official misconduct for which they must be removed from their employment?
I believe that it is significant that being the sheriff of the city that engaged in and was convicted of and pleaded guilty to domestic violence is the wrongful behavior that constitutes constitutes official misconduct.
Okay. Let me ask you, what if a deputy sheriff gets convicted of a crime? Must they be removed from office?
If it is similarly situated in similar circumstances, that would probably be the conclusion.
Okay. And if you discovered that there were deputies within the San Francisco Sheriff's Department who were similarly situated yet were not terminated, would that change your opinion?
Not necessarily.
Okay. You also say that because Sheriff Mirkarimi was sentenced to time served in county jail and the sheriff is charged with overseeing prisoners in the jail, that somehow constitutes official misconduct, right?
In the context of all the actions, yes.
Okay. And you are aware that, in fact, this was a book and release procedure where the sheriff surrendered, posted bail, and was immediately released, correct?
I'm not aware of any difference of being of his arrest and any other arrests. It is still an official arrest.
Okay. Are you aware that a former sheriff of San Francisco actually spent 5 days in jail on a criminal contempt conviction and was not removed?
Objection, relevance.
Sustained.
Was it your belief after you reviewed these court records and the records, well, strike that, I'm sorry. After you saw that Sheriff Mirkarimi had pleaded guilty to the misdemeanor, false imprisonment. Did you do any additional investigation before you brought Sheriff Mirkarimi in to talk to you?
Yes.
What did you do?
I reviewed all of the court records that were available at the time from the court proceedings.
Okay. Did you seek to speak with any witnesses to that case?
Objection, deliberative process privilege in terms of who the mayor spoke with in regard to the case.
Mr. Kopp, you did ask that question earlier.
I'm not asking for the name.
You're asking, did you talk to
Did
anybody?
he seek to speak with any witnesses? And I can narrow it.
Okay, I think the did you talk to any witnesses is okay. Overruled. You may answer, Mr. Mayor, if you recall.
Yes.
Which witnesses?
Ivy Madison.
Objection.
Answer,
Did you talk to Eliana Lopez?
Same objection. The deliberative process privilege applies in terms of who the mayor consulted with when making high-level policy decisions like the discretionary decision at issue here.
Mr. Kopp,
You know,
response?
I don't have a response because I haven't had a chance to research the deliberative process privilege because it appears to be common law and not statutory. But the mayor has discussed talking to Sheriff Mirkarimi and not anybody else. So, I mean, I think that that is fair game here.
Okay, where does he say that?
In paragraph 6 of his declaration, I met with Sheriff Mirkarimi, spoke with him, and gave him an opportunity to resign.
Where does it say he didn't speak to anybody else?
Well, I think that's inferred from the lack of mention of him speaking with anybody else.
Mr. Embledge, do you have any insight into whether the deliberative process privilege would apply here?
The deliberative process privilege has been, as Ms. Kaiser stated, applied by the California Supreme Court as to Governor Duke Magin and who he met with in making policy decisions. Certainly that would be a useful analogy. I'm not aware of any reported case where the deliberative process privilege has been applied in a situation where charges were filed against someone, but I'm not sure that's an important distinction.
Does it matter that the people that the sheriff is asking about are not other officials, but just lay citizens?
No. In the Duke Magin case, it was a request by the press to examine his appointment book, and the issue was he should be free to meet, the governor should be free to meet with whoever he wants to meet in order to make a policy decision outside or inside the government.
Does the privilege attach to the witness who spoke to the executive? In other words, does Ms. Lopez have, she's not bound by that privilege?
Not that I'm aware of. I'm not aware of anything extending the privilege in that manner.
Okay. Do any of the commissioners have views on this? Ms. Kaiser?
I would like to address the waiver argument, which I have not had an opportunity to speak to before. There is case authority for the proposition that unlike attorney-client privilege, or usually it's attorney-client privilege where you tell part of the story and you've opened the door to full disclosure, that is actually not the case with deliberative process privilege. It is possible and desirable for an official to be able to discuss what they did in terms of reaching a decision without having then to disclose everything they did and everyone they spoke to. So the case law has held that there is no waiver simply because you've disclosed something about the decision-making process that you went through. So the mayor is entitled to disclose what he has disclosed without being compelled to then discuss the names and identities of everyone he spoke to while making the decision. And the case authority for that is Blue Lake Forest Products versus United States. It's 75 Federal Claims 779-791. It's a 2007 case.
Do you have anything else to say?
It's a little hard to research this on the fly. My apologies.
I'm going to sustain the objection.
Let me ask you this, Mayor Lee. You met with the sheriff and asked him to resign, correct?
I did meet with the sheriff, yes.
And when the sheriff came to meet with you, he came with a lawyer from the sheriff's department, right?
I believe he did come with somebody, yes.
And you decided that you didn't want to have that person present, but you wanted to meet with the sheriff one-on-one, correct?
Relevance? Objection?
Overruled.
I asked him if he would come in by himself to talk with me.
Okay. And when you spoke with him, did he offer to make his wife available to you so that you could speak with her before you made any decision on this matter?
I don't recollect the exact words, but I believe he made some assertion in that direction.
Okay. Offered you her phone number if you wanted to speak with her?
I don't recall that.
Okay. Did you ever speak with Ms. Lopez?
No.
Okay. And that's because when you brought the sheriff in, your mind was made up. You were going to give him a choice, either resign or we'll file the written charges.
I had determined what direction I had. I gave him an opportunity to come meet with me and talk with me. We did. And had an opportunity to tell him what we were going to do and also give him some time to think about it.
Well, one day, right?
Yes.
Okay. And so is your testimony that when he came to meet with you, you had an open mind about what you were going to do? That is, if the sheriff could persuade you that this conduct didn't warrant him being removed from office, you might not have done that?
I was open to listening to him, but I was also clear that I wanted to indicate to him what I was considered doing.
Okay. So as of the day before you filed the written charges, you still had not decided what you were going to do?
Objection, misstates testimony.
The witness can clarify if that misstated his testimony. But you may answer if you can. Do you have the question in mind? Yeah. Can you read back the question? Or do you want to ask?
I'll try to re-ask it. You had two meetings with the sheriff, and one was on one day and one was on the very next day, right?
I had one meeting with the sheriff, and then I had another conversation with him on the telephone.
And were there not two meetings that both took place in your office?
Objection, vague.
Sustained.
Isn't it true that you met with him on two successive days and both meetings were in your office?
Objection, vague.
Do you understand, Mr. Mayor, what he's asking?
I don't recall having two meetings in a physical meeting with Mr. Mirkarimi at the time.
Okay, so your best memory is that the first meeting was in person in your office, and the next time you talked to him was by telephone.
That is correct.
And it was on the second time that he told you he was not going to resign, correct?
That is correct.
Okay. And at that point, you had decided that you didn't think Sheriff Mirkarimi was fit to be employed by the city of San Francisco, right?
I had, at that time, come to a final conclusion that he had conducted himself with official misconduct and he had engaged in the wrongful behavior and came to that conclusion.
Okay. Did you ever extend an offer through third parties that if he would just resign, you'd find him another job in the city?
Objection, relevance.
Mr. Kopp, where are you going with this line?
Credibility. If he didn't think he was fit to be sheriff, why would he think he would be fit for a city job?
Ms. Kaiser?
I would continue to object on the basis of relevance, and I also don't think it goes to bias. Many times there are problems that people try and resolve with compromise, and that does not mean that they don't believe that there is an actual problem.
I understand your objection. That the mayor, though, has put at issue the reasons why he suspended the sheriff in his declaration, and I do. It's pretty close to the line, Mr. Kopp, but I do think, given that basis, it could arguably go to bias. So it's overruled.
I don't recall offering Mr. Mirkarimi any job.
So you never authorized, say, Aaron Peskin or Walter Wong to convey to Sheriff Mirkarimi if he would step down, you'd give him another job?
Absolutely not.
Okay, thank you. I have no further questions.
Thank you, Mr. Kopp. Ms. Kaiser, do you have any redirect?
Yes, I do. Thank you. Good afternoon, Mr. Mayor. When you said that the sheriff beat his wife in a recent interview, as you just discussed with Mr. Kopp, did you make a distinction in your mind between a little domestic violence and a lot of domestic violence?
No, I did not.
Do you believe there's such a thing as just a little domestic violence?
No, I came to the conclusion he did commit domestic violence. He admitted to it, and that's the conclusion I have.
Why did you not call Eliana Lopez?
I did not believe that discussion with her had anything to do with the decision that I was responsible to make with respect to official misconduct.
Why not? Why did you not need any further information from her?
Because I believe that the record that was established through the court, the criminal actions that were confirmed, the plea of guilty, were enough to define the wrongful behavior for official misconduct.
So is it fair to say that you relied on his guilty plea instead of calling his wife?
Sustained.
What was the main criterion in your decision, if there was a main criterion? What was your main criterion when you reviewed the record and the information that you had and decided that there was a reason to state a charge of official misconduct?
The question I had is whether he actually did engage in criminal activity, that whether he had perpetrated domestic violence on his spouse, and whether, and as I read it, he admitted to a false imprisonment.
What convinced you, if anything, that he had actually done these things?
Primarily his plea to that charge, and the acceptance of the sentencing that goes with it.
Did you understand his guilty plea to be an admission on his part that he actually did what was charged and what he pled guilty to? I'm asking about his understanding.
But it's a form objection. I'll sustain it. Can you just rephrase?
What, if anything, did you understand the plea that he entered of guilty to mean about his actual culpability?
That he was the one that admitted to being guilty of the charge of false imprisonment, that is domestic violence, and that he caused the physical bruising on Ms. Lopez's body.
Do you have an understanding, Mr. Mayor, or an expectation of the relationship between a guilty plea and factual guilt?
Objection, that's beyond the scope.
Overruled.
Guilty plea is, in fact, the admission of those facts that support that allegation.
So You've been criticized for not calling Eliana. Why? You've also, it's been noted in the sheriff's declaration that, and elsewhere in public, that you did not complete a full investigation before you brought charges. Is there a reason why you were prepared to bring charges when you did?
Counsel's testifying.
Overruled.
I waited for the whole criminal prosecution to complete itself. And as I said earlier, out of respect for Mr. Mirkarimi's rights as well as the judicial process, I waited for the full conclusion and then asked to make sure that I had the complete record and reviewed what I could in order to make that determination.
Was there any reason why you didn't then also conduct your own full investigation?
I believe that the court process established the facts and the plea, and that was sufficient to confirm the wrongful behavior.
Why didn't you suspend Sheriff Mirkarimi with pay?
I believe that that position requires someone who is working in order for the city to pay that person. And if that person is not permitted in this case to work, and it was a result of these circumstances that I felt it necessary to suspend without pay.
Well, why didn't you treat him as innocent until proven guilty?
Because he had already pleaded guilty to this charge, and the court confirmation of this was its conclusion.
You mentioned, well, Mr. Kopp mentioned, and you agreed earlier, that there are some political issues between you and my boss, Dennis Herrera. Is he your political ally? Was he in the last, maybe I'll withdraw that. Was City Attorney Dennis Herrera your political ally in the last election?
I don't think so.
Are you planning on suspending Dennis Herrera and bringing charges of official misconduct because he was not your ally in the last election?
Sustained.
Mr. Mayor, do you think you're more prone to bringing official misconduct charges against people who are not your political allies?
Overruled.
No.
A sheriff is a department head in San Francisco, is that correct?
Yes.
Is there any department head of any department who could plead guilty to domestic violence and not be removed for official misconduct?
You asked the same types of questions. I'll overrule that.
I would find that would be a serious enough charge to fulfill official misconduct, certainly wrongful behavior.
Any department head?
That's correct.
Okay. Did you have any special concerns of any sort that the department head in question who had pled guilty to a charge of domestic violence was the sheriff?
I think there is added significance because the sheriff is one of the top two law enforcement positions in the city.
Can you say more about how that is significant in your view?
One of the more disturbing aspects of this is my knowledge that the sheriff is in charge of responsibilities with respect to domestic violence victims, and that it has historically been a very strong program in the city of San Francisco, shared by several various departments to do their part to prevent and to respond to and to encourage witnesses to come forth in an effort to end domestic violence. And that the Sheriff's Department is a key to those various agencies that have that responsibility. And for the sheriff himself to be confirmed as engaged in this is significant.
Do you believe you should lead by example, Mr. Mayor?
Yes, clearly.
Do you believe that part of leading by example is showing the power of redemption?
That's certainly something that I've learned, particularly as applied to domestic violence.
Couldn't you model redemption by dropping the official misconduct charges against Sheriff Mirkarimi and giving him a second chance?
I came to the conclusion of official misconduct because I believe that the actions that were admitted to and the crime that was perpetrated has to have direct consequences. And I believe strongly that a direct consequence is that you cannot be sheriff of the city if you are guilty of domestic violence.
Do you think, as you sit here today, that the sheriff is ready for a second chance from you as the decision maker?
Objection, relevance, speculation.
Sustained.
Mr. Mayor, does the sheriff have any duty to work together with the mayor?
Yes.
In light of the events that have transpired since you brought the official misconduct charges and the discourse that has been in the, well, let me back up. Are you aware of any statements that have been made about you in the press by the sheriff or his attorneys? I'm laying a foundation.
I'll allow that. Overruled.
Some.
Have they been friendly assertions?
I don't believe so.
Are they the sorts of assertions that you believe you could get past and rebuild a relationship with the sheriff so that you can work effectively together if he's reinstated?
It'd be extremely difficult.
One last question, Mr. Mayor. In terms of official misconduct charges, are you the decision maker in the process, the ultimate decision maker about whether the sheriff should be removed?
I'll allow that. Overruled.
I am not.
So are your conclusions and your beliefs, as you understand this process, to be the final word on whether the sheriff has committed official misconduct?
No, I have brought the charges based upon the facts that I've seen, and I know that it is the ultimate responsibility of two additional bodies to confirm that.
So as you understand it, does this case rise or fall in any way on your opinions?
Objection, relevance.
Overruled.
It does not.
Thank you, Mr. Mayor.
Briefly, Chairperson.
Yes, Mr. Cobb,
Chairperson.
please proceed.
So, Mayor Lee, you said essentially that your feelings have been hurt by some of this stuff, and you'd find it extremely difficult to get past that and work with the sheriff.
Objection misstates testimony.
Please rephrase. That's
All right.
objection sustained.
Mayor Lee, you just testified that based on things that have been said during the course of this proceeding, you would find it exceedingly difficult to work with the sheriff if he remained in office, right?
That's correct.
Okay. Let's say this process concludes and you don't have the votes in the Board of Supervisors and the sheriff remains sheriff. Are you telling the commission that you will refuse to carry out your duty to work with the sheriff?
I'm not going to refrain from any of my duties, as I haven't up to this time. I will continue carrying out my duties, if that's
Right.
what you mean.
And if these removal proceedings do not result in the removal of Sheriff Mirkarimi, of course, you will put aside your feelings and do what's best for the city and work with him, right?
Yes.
Just as you put aside your differences with Mr. Herrera and you're working with him, right?
Yes.
Thank you. Nothing further.
Do any commissioners have questions for the mayor? Mr. Mayor, thank you for your time. You are released.
Thank you.
The next witness, I understand, will be Chief Lansdowne. Madam Court Reporter, if you will please swear the witness.
You solemnly swear or affirm to tell the whole truth and nothing but the truth, so help you God?
I do.
Thank you.
Thank you.
Good afternoon, Mr. Lansdowne.
Good afternoon, Commissioner. It's truly a pleasure to be here. And I've been in this business for a long time. This is the best hearing I've been in 47 years. You're doing an incredibly good job.
I appreciate the sentiment, but I think I would strike that from the record.
Good afternoon, Chief Lansdowne.
Good afternoon.
How are you?
I'm doing very well. Thank you.
All right. Thank you for making the trip here. I want to ask you some questions about your declaration. Now, I understand you've been retained by the mayor to serve as his expert witness, correct?
That's correct. I've been asked to come here and testify for them.
And can you give me an estimate of exactly how many hours you have spent reviewing documents, consulting with the mayor's lawyers and/or the mayor, and drafting and editing and preparing your declaration?
Objection to the extent, and only to the extent, that any of that would intrude on attorney-client privilege.
Overruled. You don't have an attorney-client privilege with an expert.
You're right, work product.
Overruled.
I would estimate 40-plus hours.
40-plus hours. And you also submitted a list of all the materials that you've reviewed, which were fairly voluminous, right?
Yes, sir, I did.
Okay. And you've been in law enforcement for a long, long time, right?
Yes, sir.
And you have lectured on ethics of police officers, right?
That's correct, sir.
And you'd agree with me that police officers or sheriffs are human beings like everybody else, right?
Yes, sir, they are.
They're not always perfect, right?
No one's always perfect, sir.
And you've trained many officers. Actually, I think if I read your declaration correctly, you said you trained every officer in the San Diego Police Department.
And in San Jose and in Richmond, California.
And so that's personal training that you've given these officers when they come on the force?
Yes, sir, day one when they walk in the front door.
How do you have time to do anything else?
They come on in a series, sir.
Okay. And you instruct officers about how to be a good cop, right?
Absolutely.
And some of them listen to you, and some of them kind of go by the wayside, right?
Some of them make mistakes. That's true, sir.
I mean, within your own department, there are currently lawsuits and allegations of police officers doing improper things, right?
Yes, sir. In any big city, you're going to have some issues to deal with.
Sure. Now, you talk about your knowledge of sheriffs because you've been involved in these organizations where there are different kinds of peace officers there, right?
Yes, sir.
Okay. Now, in the county of San Diego, is there a sheriff?
Yes, sir, there is.
And they have an area that they patrol?
Yes, sir.
So they're actually patrol officers, and they're serving the function that's equivalent to police officers in municipalities, right?
They have a patrol function, but they also have a very large custody function, and then the courts that they deal with, and a lot of the civil procedures and policies that they have to enforce.
Right. And you're aware that in San Francisco, the primary responsibility of the sheriff, because it's a city and county, is to keep the jail and execute orders of the court, right?
The primary responsibility of the sheriff is similar to my job. We manage people, we manage a budget, we set policy, we work with the community and certainly with government, and jail and some of the other procedures they have are certainly a little bit different than ours. But we don't get involved, nor does the sheriff get involved in the hands-on at the ground level. We're a much higher level than that.
Okay. But the sheriff's department in San Francisco, they don't have deputies that are out there on patrol doing the work of police officers, right?
No, sir.
Okay. So this sheriff's department is unlike any other in the other 40 or 50 counties in the state, right?
Yeah, because
Inspection, not in evidence, no foundation.
Overruled.
I don't think they're much different. They don't have the patrol function, but they still have the function of being the sheriff, the lead investigator, the lead law enforcement person in the county of San Francisco.
Well, when you say lead investigator into what?
They are the ones that the county of San Francisco look at as one of those people that is the one that sets policy, that sets standards of acceptable behavior for law enforcement. When you talk about law enforcement in San Francisco, you talk about law enforcement in San Diego. It's the chief executives that they were talking about. That represents law enforcement in either county.
Okay. And it's your opinion that peace officers have to be held to a higher standard than other public servants, right?
Yes, sir, and I believe that chiefs, executive officers, and sheriffs must be held to an even higher standard.
All right. And you also believe that if peace officers are convicted of crimes, and if they haven't passed their probationary period, they ought not to be hired, and if they have, they ought to be fired.
I know of no personal situation that I've been involved with, nor other officers or at least chiefs or sheriffs that I know of, that have had probationary officers who have gotten into criminal charges that have not been terminated from their organizations.
Okay. Do you know of peace officers who have been convicted of crimes after they've become full peace officers and have stayed on the job?
Yes, sir.
Okay. And that's even happened in the case of the sheriff of a county, right?
I'm not sure which county.
Robbie Waters in Sacramento?
Objection, relevance.
Overruled, but let's get on with it.
I read that in the declaration of Sheriff Hennessy, but I'm not sure, and I know nothing about that particular incident.
Okay. So you have read Sheriff Hennessy's declaration?
Yes, sir, I did.
And you're aware that he was sheriff here for 32 years, right?
I admire the work he does.
And is it fair to say that he's probably the primary expert on the San Francisco Sheriff's Department?
I would say that he would be very knowledgeable about the San Francisco Sheriff's Department. That's correct, sir.
Okay. And you're aware, having read his declaration, that there are numerous sworn and unsworn employees within that department who have suffered criminal convictions, right?
Yes.
And in fact, one of his top non-sworn personnel members went to prison for manslaughter, right?
I was unfamiliar with that.
Okay. Well, after you read that in his declaration, did you follow up on that to find out more information about it?
I did.
And did you find that to be true?
I did.
And did that indicate to you that perhaps the standards within the San Francisco Sheriff's Department might be different than they are in other departments, whether they are police or sheriff's departments around the state or the country?
No, it did not. My true and honest belief that the sheriff himself would hold himself accountable, and other sheriffs and other chiefs of police would hold themselves accountable.
But doesn't the fact that the San Francisco Sheriff's Department has had sworn and unsworn personnel who have suffered criminal convictions, doesn't that lead you to believe that maybe the culture in the San Francisco Sheriff's Department is maybe different than in other departments that you know?
I believe all departments probably have some officers who have been arrested and convicted and still operating within their organizations.
And likely there are many of those officers who are still doing a good job, right?
Correct.
So the mere fact in and of itself that a peace officer suffers a criminal conviction does not automatically mean that they are unfit for the job, correct?
I think you need to define the term, sir. We're talking about sheriff and chief and peace officer. They're two distinct and different positions. One makes policy, one sets priorities, and one is the face of their organization. That's the sheriff or the chief, and the standard for them is unequivocally higher than anyone else in that organization.
Okay, so if, for example, the sheriff of a county suffered a criminal conviction, it would be your opinion that they would be unfit to hold the office, bar none.
Absolutely.
And if that's ever happened, you couldn't understand the reason for it.
I would not think that it would be in the best interests of the county that they serve.
Sure. Now, you yourself have never held elective office. Am I right about that?
I've never run for elective office. No, sir, I have not.
And you understand that sheriffs are constitutional officers in that the Constitution says they are one of the 5 offices in each county in the state that are elected, right?
That's correct, sir.
And you believe in the democratic process, right?
Oh, absolutely. I've been defending it for 47 years.
Okay. Now, one of the things that you wrote in your declaration is that if the sheriff doesn't hold himself accountable, no one else is in a position to do so. And for anybody who cares, this is on page 14 of the declaration, paragraph 50. And then you said, short of committing official misconduct, the sheriff answers only to the voters and only once every 4 years. That's what you wrote, correct?
Correct.
Okay. Are you aware of the provision that provides for the voters to recall the sheriff as well as every other elected official in the city?
Yes, sir, I am.
Okay. So, in fact, there is another way besides an official misconduct proceeding that the sheriff could be removed.
There is another way to do that. That's
and
correct.
That is the democratic way to do it.
Objection, argumentative.
Well, it involves.
Sorry. Can I have the question read back? I was thinking about the objection, so I didn't want to get the answer in.
And that is the democratic way to do it.
Overruled.
I don't know if we got your answer, sir.
Could you repeat the question?
Sure. The other way to remove the sheriff would be the democratic process where voters cast votes, right?
Yes, sir.
Okay. Now, one of the other things that you stated in your declaration, you found a lot of fault with Sheriff Mirkarimi. Safe to say that, right?
Correct.
All right. And you noted that Sheriff Mirkarimi didn't take any corrective action and did nothing to disavow improper conduct like witness dissuasion, right?
Yes, sir.
Okay. Did you see the text message where his wife implored him to contact the ex-sheriff and use his power to do something, and he responded that he could not and would not do that?
I don't know that I saw that particular text, sir.
Okay. If I were to tell you that there is such a text, would that change your opinion as to whether or not he disavowed that kind of conduct?
No, sir, it would not.
All right. You also faulted the sheriff for his refusal to cooperate with investigators, right?
Yes, sir.
And is it your opinion that as soon as a criminal investigation was undertaken by the San Francisco Police Department that Sheriff Mirkarimi was obligated to speak with them?
He has the same right as anyone else that's accused of a crime to take the fifth, if he so desires to do that. Absent that, he would be required to have some responsibility to assist and help them in their investigation, if possible, with some lawyer's advice.
Okay. Now, when you say that he's got this obligation to cooperate with law enforcement, that's based on the police officer code of conduct, right?
I believe it's in their policy as well as my policy and every other policy of the state of California, that you will cooperate in investigations with other agencies. It's required. You can't operate without agencies interacting.
Right. But you would agree with me that if a person has a Fifth Amendment right, which is guaranteed by the United States Constitution, that might trump a departmental policy.
With a police department?
Yes.
He would have the right to take the Fifth and not cooperate. That's correct, sir.
Okay. And so when there's a criminal investigation and then a criminal prosecution ongoing, person's entitled to not speak to the authorities, right?
That's correct.
All right. Now, you've also you faulted the sheriff for the way that his firearms were surrendered to the authorities after this emergency protective order was issued, right?
Yes, sir.
Okay. Isn't it true that the protective order just stated that he was to turn over the firearms within, I don't know, 24 or 48 hours to law enforcement?
Objection, no foundation.
Is that your recollection of the document, sir?
Objection, no foundation that he reviewed the document.
Why don't you lay some foundation?
Sure. Did you ever look at the actual order for him to turn over the guns?
I've never seen the order.
Okay. And correct me if I'm wrong, but isn't the purpose of that order to get firearms or any weapons that may belong to someone suspected of a crime such as this out of the hands of the person who is suspected and into the hands of law enforcement?
Correct, to the investigating agency, correct.
Well, it doesn't really matter where they go as long as they get into the hands of law enforcement, right?
Well, usually those orders are directed to an agency, and it's their responsibility to collect that evidence.
Okay. And you have the opinion that Sheriff Mirkarimi misrepresented to the San Francisco Police Department how many guns he possessed. Is that right?
My understanding of the information I received, that he said he had 2 guns when clearly it was registered for 3.
Okay. And if his statement actually was, I think I sold that one other gun a long time ago, and he was merely mistaken about that fact, would that change your opinion?
My belief is that I know where all my guns are, all my friends know where their guns are in this business of law enforcement. You don't lose guns or forget where they were.
Well, you've heard the sheriff describe the manner in which his guns were stored, correct?
Oh, yes, correct.
And you don't find fault with the way he made sure they were safely inoperable and taped them and locked them and all that, right?
No, I thought that was good.
That was
the first I've heard that, but I thought that was good.
Right, and that's how you would advise any peace officer to store weapons so as to make sure that they're not dangerous for somebody to come upon and discharge accidentally, right?
Well, I tell everybody the same thing, is they ought to have a gun safe and lock them up at night.
Okay, that's like the gold standard. But
it is the gold standard.
In fact, many law enforcement officers don't follow that standard, right?
Some don't.
Okay, and there are peace officers who you know of who may momentarily forget where they put a weapon, particularly if they haven't used it in years, right?
It's possible they could. I don't know of any, but there may be.
Okay. I mean, you'd agree with me that the human mind sort of, over time, you can forget certain things, right?
Well, there's a difference between misplacing the weapon, sir, and saying you sold it.
Right. And so you base your opinion and your testimony on that issue based on what you've seen other people say about whatever the conversation was between the sheriff and the San Francisco police inspectors, right?
It's the only information I have to base it on, sir.
Okay. Now, you also have, you've made your comments that the sheriff didn't adhere to his own department's ethical standards, right?
Yes, sir.
Okay. And because he committed this act with his wife and then he was charged and convicted of a crime, right?
Correct.
Okay. And let me ask you this. If there was a deputy sheriff within the San Francisco Sheriff's Department who fell below those standards and wasn't terminated or at least suspended for a very long time, would you say that the sheriff had fallen below his standards for failing to adequately discipline that deputy?
Yes, I believe the sheriff or a chief would have the responsibility to hold his personnel accountable, and just as important, to have the courage to hold themselves accountable.
And you've said that people who are involved in running the prison or the jail require that the person have a clear criminal record and exemplary.
I'm sorry, I didn't understand that. Can you say it again?
Exemplary?
No.
Let me strike that question and start over. You have stated in your declaration that the standard for a person running a prison or jail requires that the person have a clear criminal record and exemplary personal conduct, right?
You're talking about the sheriff? Yes.
Well, I mean, no, I want to ask you, are you referring to the sheriff or anybody working in the jail?
The sheriff.
Okay. So it's okay if some of the jailers or deputies who are subordinate who are actually working in the jail, if they have a criminal record and exemplary or less than exemplary personal conduct, but it's not okay if the sheriff has those characteristics.
I believe the sheriff has to have the higher standard, and then there would be individual instances or cases where probably some people have committed some crimes and are allowed to work because they're under close supervision, because we can control the environment that they work in while they're there in the police department or the sheriff's department, and because we can place them on what I call a last chance agreement, which any other violation would be instant termination for that employee.
All right. Now, you also rendered the opinion that because the sheriff has to maintain effective working relationships with other government agencies, that is your opinion that it would be impossible for Sheriff Mirkarimi to work with the other agencies in San Francisco if he's not removed?
I didn't say that it was impossible. I'd say that relationship is damaged, and I can tell you from my experience and then from the other chiefs or sheriffs that I work with pretty regularly, that this relationship is vital, our working relationship, in exchanging information, in understanding that as we work together, that if there's an issue or problem, we'll come to you quickly because it's a matter of trust between all the different agencies. And once you start to break that trust down, you don't quite work quite as well, and by not working quite as well, it puts the community in danger that we all serve.
Okay. And your opinion is Sheriff Mirkarimi will be unable to rebuild these relationships in the near term and perhaps not even in the long term. That's what you wrote, right?
That's correct.
Okay.
When you accuse them of misconduct and in some sort of conspiracy, it creates some real problems for the other agencies, especially when they're doing nothing more than to try to do their job in the best and most professional way they can.
Okay. And but you've been around long enough to see that sometimes political opponents who wind up being elected to elective office can be bitter rivals, bitter enemies, and then later on they find a way to work together, right?
I've seen that happen, yes, sir.
Okay, so you're not going to testify that if these removal proceedings don't end with the removal of Sheriff Mirkarimi, you're not going to say that it will be impossible for him to rebuild these relationships.
I don't believe there's anything impossible, but the amount of time it takes to rebuild those relationships or the trust that you have to keep within a community takes a long period of time. And an incident may take place where you need that cooperation today or tomorrow, not a year from now, not 2 years from now. It's critically important, sir, that we work together well and effectively.
Okay. And now within the Sheriff's Department itself, I mean, that's like a command structure. It's like a paramilitary organization, right?
Yes, it is.
People are given orders and they follow them, right?
It's got rank structure.
Okay. And you have no reason to believe that if Sheriff Mirkarimi retains his office, his subordinates will defy his orders?
It is my true and honest belief, sir, that the officers, deputies, They desperately want the chief to be the person that they can be proud of. And they want to be able to hold him up or hold her up and say, this is the person that we work for. And they want to do that with the ability to be true and honest when they say that. And when you break that bond of trust, when you don't lead by example, not from what you say, but from what you do every single day. We're probably the most watched people in America, police chiefs and sheriffs. You lose credibility with them. And once you lose credibility, they say, we're going to be like you. And it's a problem. Because they say, there's two standards, one for the sheriff and one for us.
Okay. Have you spoken with any deputy sheriff here in San Francisco that says, hey, if Sheriff Mirkarimi comes back to the job, I'm not going to do what he orders me to do?
I have not talked to any of the deputy sheriffs in your police department, but I have talked to deputy sheriffs in other agencies, and certainly within the major city chiefs, the 63 largest agencies in America. That's from New York to Chicago, from Las Vegas to Sheriff Doug Gillespie, or the largest sheriff's department in the country, Libaca. And I think the finding would be exactly the same. They want that person to be above reproach.
Okay. I'm going to move to strike everything after the first clause is non-responsive.
Granted.
Thank you. Thank you, Chief. I have nothing further.
Thank you.
Redirect, Ms. Kaiser?
Yes, please. Good afternoon, Chief.
Good afternoon.
If a officer or a deputy who is being investigated by a law enforcement agency chooses to take the fifth instead of cooperate with the investigation, does that have the same consequences internally for that officer's discipline?
Well, there are two investigations that take place in any discipline with a person other than the chief and or the sheriff. And the second part of that is the administrative investigation. You have a criminal investigation that takes place, and that officer or deputy can take the fifth and work only with their attorney and present whatever case they would like to present. But you also have an internal investigation. That's the internal affairs part. And we have what we call reverse Miranda, which means once we reverse Mirandize you, you must talk to us. And if you don't talk to us and tell us the information that we're looking for in an honest and clear fashion, you can be terminated for insubordination for that and that alone, for not cooperating in the administrative investigation. That doesn't apply to the sheriff or the chief.
Why is it important to have such a harsh rule?
Because the business of law enforcement, it's a noble profession. It's a gift. People give us a trust. And every time we send an officer out on the street or deals with a deputy who's working in the jails, you've got to trust what they do. And if you have a belief that they've committed some misconduct that is criminal in nature, you have an obligation to investigate it and get the information as quickly as possible to make the decision. You're either going to keep that person or you're going to move that person or going to take some disciplinary action to correct it so that the people in the jail and or the people in the public, the community that we serve, are treated fairly and honestly every single day.
Moving on to the order that required the sheriff to disarm and surrender his weapons. Mr. Kopp was asking you, isn't it sufficient, doesn't it disarm the batterer if he gives his guns to law enforcement? Doesn't it just say law enforcement? Maybe that's basically the gist of the testimony as I remember it, and you can correct me if that's incorrect. Why doesn't, if it doesn't, a protective order like that say you must surrender your firearms to a different law enforcement agency than the one that you run?
Because the chief investigators, those that are working on the case, want control of those items because there may be more to the case that we're not aware of at that time. It's not only the battery that you're looking at that time, but whether or not there are other issues or cases that may involve those weapons. The possibility of that happening are remote, but certainly real.
As the chief of a police department, if you gave your firearms to a subordinate officer, would you have the authority to get them back?
I have no doubt that if I went to one of my offices...
Hold on. What's the basis? He's an expert. I'll overrule it.
I have no doubt that I went to one of my officers, the chief of police of the San Diego Police Department, and said, give me the guns. He would give them to me.
You mentioned something called a last chance agreement. What's that?
In the system of discipline that we have across California, most of the time it's progressive discipline. It builds on itself until you get to the point where you're going to terminate someone, because that's a very serious response to misconduct within a police department. And in many cases, what we do is, like drunk driving is probably a good example. If somebody is arrested and convicted for driving under the influence, they may be suspended. They may be put on what we call last chance, which means if they agree not to be terminated, and if they agree, at least in our department, to periodic drug testing, looking for alcohol, that they can retain their job. But if they have any other violation that relates to DUI, drunk driving, or coming to work under the influence, then they would be immediately terminated, and they have no recourse to go through civil service. It's a last chance agreement. It says this is serious what you've done, and our response is very serious to manage it.
If you were convicted, let's say, of DWI or driving under the influence, would you enroll yourself in your last chance agreement program?
Yes. Well, if I was arrested?
If you were arrested.
Oh, I'd be fired. I'm an at-will employee. There's no second guessing on that. If I had an option, I would, but I wouldn't get that option. And the truth is that I can't say it stronger. It's a gift being a chief or a sheriff, and it's a responsibility, and it comes with awesome authority. We set policy, we set the procedures in place. We say what's important, what's not. We organize priorities. We protect the communities. We move people around on a daily basis. And in order to do that, you've got to have a couple of things. You've got to have the trust and support of the politicians that you work for. You've got to have the trust and support of the officers. And you've got to have the trust and support of the community that we serve, all three legs. And if you lose the trust of any two of those, it's time to remove yourself from your position. Being arrested as a chief of police, my experience, they have left gracefully. If I was arrested for DUI, I would leave the department gracefully, because the damage I would do to this department would be incredible. I could not repair it in the time that I have left in this business, this wonderful business of law enforcement.
Would you compare overcoming political rivalries with being a convicted criminal making accusations against coordinate criminal justice agencies? Is that the same caliber of dysfunction that you could overcome? Do I need to
Please, maybe you
restate
could
it?
restate that. It's just a little complex.
Yes, it is. I'm sorry. My fault. You were asked if you were aware of whether elected politicians who had rivalries were sometimes able or often able to overcome them and work together effectively and mend broken fences. Do you think that that is the same sort of problem that Sheriff Mirkarimi would have coming back to his position and working with other criminal justice agencies like the DA or the police or adult probation? Is it like political rivalry, or is there something else, something more in this situation?
Well, there's a lot more in this situation. If you're talking about public safety and our relationship and how we work together, and how important it is to have that trust, because when we're standing together on a street or in a riot or Occupy movement we had, you've got to trust that person standing next to you to cover your back, and you've got to have a belief that both of you have the same desire to get through that incident as effectively and as quickly and as safely as you possibly can, and still hold the understanding that this gift that we get is a trust with the community to be able to manage it.
Does it matter to you that Sheriff Mirkarimi pleaded guilty to domestic violence? Is that the same in your mind, to rephrase, as simply being accused, or does it carry more significant weight in your opinion?
It certainly carries more weight. He did the issue. He pled to the crime. I admire him for doing that. But it says he did it. He committed an incidence of domestic violence. And domestic violence are one of those things that we treat very seriously across California and the nation. It's very clear that my understanding is 1 out of 4 of all the women in America are a victim at one time.
Are you making a motion to strike it?
I disagree. I asked him, well, we can read the question back if you'd like.
Can you actually read the answer back?
Certainly carries more weight. We did the issue. He did the issue, pled to the crime. I admire him for doing that, but it says he did it. He committed an incidence of domestic violence. Domestic violence is one of those things that we treat very serious across California and the nation.
Okay, you can stop right there. Everything from domestic violence is a serious offense across the nation. That part is stricken. It's been a long day already. Please proceed.
In your mind, does it make a difference that he pled guilty and was convicted of domestic violence as opposed to a DUI?
Well, I think domestic violence is a crime that is more than just an accident or a one-time incident. I think it's significant when you look at domestic violence that it is a behavior that needs to be corrected over a long period of time. I think that when you plead guilty to domestic violence, my understanding and my experience shows me that usually when you have a victim report domestic violence, it's not the first time, but the time.
Why don't we let the witness finish the answer, and then I'll entertain the motion to strike.
It's not the first time. Usually they develop the courage to step forward and report that incident about the 6th or 7th time that it occurs.
Are you making the motion? Everything after it's the first time is stricken. I'm sorry, I think he said it's not the first time. That part from there forward is stricken from the record. Please proceed.
Do you have any other concerns about the fact that a sheriff would have committed domestic violence as opposed to some other kind of crime like DUI?
Yes, I do. It's a crime that is violent in nature, that it is about control and power, and that as I talk about behavior, it's a behavior. There's a tendency to use that control and power to their own benefit.
And why are those things concerning?
Because you're in a position to use control and power every single day.
Do you have an opinion about why it may or may not be important to victims or witnesses that the chief law enforcement officer committed domestic violence?
Yes, I do.
And what's that opinion?
No foundation. I mean, this whole thing is about that. That objection is overruled. You may answer.
Could you repeat the question?
Madam Court Reporter?
And what's that opinion?
Can you read the prior question, please?
Do you have an opinion about why it may or may not be important to victims or witnesses that the chief law enforcement committed domestic violence?
Yes, I do.
And what is that opinion?
My opinion is this, is that there are lots of victims of domestic violence, and they're frightened to report it. And they want to know that the police department is going to be responsive in a compassionate and caring way, that they won't become the victims, but they will be somebody that department or agency or sheriff steps forward to be able to manage that and make sure that their interest in their life is protected in the process. And as you look at that concept, the person that they need to trust the most is the chief executive, law enforcement executive, because they don't often see the people who do the work every single day, but you see the sheriff and you see the police chief in the news every single day, or at least almost every single day. And as you see that, that person is the personification of what law enforcement's all about. And that's the person that you have to trust. And if you have a belief that they're somehow biased or unresponsive or not compassionate in the process, they won't report it. And you want to reach out and make sure that the victims of domestic violence are encouraged to step forward to be able to report it.
Do you think it's possible to violate the standard of professional conduct for a chief law enforcement officer by failing to do something?
Yes.
Do you think that Sheriff Mirkarimi has failed to do things that you would have expected and that you believe would have been required of a chief law enforcement officer in this case?
I do.
Can you give me an example of such a thing?
It is my belief, after reading the declarations and certainly looking at the case itself, that there are several issues that I would be extremely concerned with in any sheriff or any police chief as a professional in this business, as someone who teaches ethics and process. You've got to encourage victims to step forward. In this case, I was taken back. I read the reports of Miss Ivory Madison. In my view, as a professional in this business, this is a true hero that stepped forward, that reached out to try to help somebody in need in a compassionate and caring way.
Objection is sustained. That part is stricken. Let's proceed by question and answer, please, Ms. Kaiser.
You were testifying about the fact, as I understand it, that it concerned you, that something about the treatment of Ivory Madison concerned you in regard to some element of the sheriff's failure to act. Could you explain that connection to me, please?
It's my belief that the sheriff should have defended someone who stepped forward to help his wife when she was in need.
Why do you believe that Ivory Madison helped his wife instead of betraying or disrespecting her?
It is my belief that Miss Lopez went to her because she was frightened and scared, and she needed somebody to sit with and say, what do I do? And she got exactly that, somebody that tried to assist and help her and step forward. And I think that the sheriff should have stepped forward and congratulated and thanked Miss Madison, not gotten to a position to allow some of the things that occurred where it seemed to question her credibility or to attack her as a person.
When a witness comes forward to report a crime, do you look into that witness's or that reporting witness's character, or whether she ever wrote a comic book or her political beliefs or anything like that?
No, we take the statements that they bring to us at face value.
You don't believe you need to investigate the nature of the reporting witness? I just want to make sure I understood properly.
The only thing that we would look at is see if there are any other reports that she may have had in process. If there's anything else to cause us concern, but if it's just a witness that steps forward, we congratulate them in every single case. We encourage it.
Does law enforcement depend on crimes being reported?
You could not operate in a sheriff's department, and you could not operate in a police department without the cooperation and assistance of those people who courageously step forward and bring us the information and do one other thing, are willing to testify. And those are the people you really need to encourage, because if you don't, it's a chilling effect on the rest of the city or the rest of the area that we police.
Do you believe that it's important to treat complaining witnesses respectfully in order to encourage them to come forward and to testify if necessary?
I do.
Have you ever had an experience in your years as a chief law enforcement officer where a victim or a witness was not treated respectfully and that discouraged them from cooperating?
I have.
Can you describe one of those instances, please?
Well, I can tell you several instances in the city of San Diego or in the city of San Jose or in the city of Richmond where they have instances of gang violence and where it's very difficult. Most importantly, one I saw was in the city of Richmond, California, where they had a very high crime rate and a very high homicide rate. And the reason we were unable to solve them when I got there was because the witnesses were terrified and afraid to come forward, and they didn't trust the police. And it took us almost a year of hard work, of reorganizing the organization, of stressing from my level that we're going to work with the community, that we're going to encourage information coming our way, that we're going to be part of the community, not someone that just visits it. And we were able to bring that homicide rate down by 50% in that first year, and it's because those victims and witnesses stepped forward.
Would it matter, in your opinion, in terms of what the sheriff was required to do or not do, that he personally didn't make attacks on Ivory Madison, but say his attorneys in this proceeding did? Is that less culpable?
It's my belief, in reading the reports, that he was in a position to stop it, and he did not do that.
Thank you.
Recross, Mr. Cobb.
Briefly, Chief Lansdowne, I think you said that you were asked a moment ago that if you got arrested for a DUI and got convicted, whether or not you'd enroll in this last chance program. And you said, if I had the option, I would enroll in the last chance program. Right?
Yeah, I got a little confused, and my apologies, sir. I was thinking of the advice that I give to the officers that step forward and say that we did that and that this gives them a chance to do what they're going to do. I would resign.
So you'd resign.
Yes.
But it's okay for your subordinates to enroll in the last
They have
chance
that
program.
option.
Okay. I don't have anything further.
Questions from the commissioners for Mr. Lansdowne? Commissioner Studley?
Thank you very much. Thank you for being here, Chief.
Thank you.
I am interested in the standard of conduct that we are expected to apply, and I wonder if you could help us. In your experience, is or should the standard of conduct, our charter says, conduct that falls below the standard of decency, good faith, and right action, impliedly required of all public officers. I'm wondering whether that should be a city, regional, state, national, or other standard that we should be applying. Is that clear enough question?
And I hate to do it, but I have to interpose an objection that this is the wrong witness to be asking. So I would object that there isn't any foundation for him to give that answer, and it calls for a legal conclusion.
Your objection is noted. It is overruled.
I believe it is a standard across California. San Francisco's just unique. They've codified it.
Clarified it?
Codified?
So you're saying it would be, you would apply a state standard in understanding that definition?
Absolutely. I believe that would raise the bar for the entire state.
On page 17 of your testimony, you talk about risk management, and you said that, just a minute, the sheriff's conviction and criminal probation compromised the ability of San Francisco Sheriff's Department personnel to effectively testify in criminal proceedings and present serious legal risk for the Sheriff's Department in civil litigation. I wonder if you could explain what you mean by that a little bit further.
I can. They have a Brady list across the state of California. The city attorneys and the district attorneys have all got together. The Brady list is a list that has all the officers who have something that would cause concern in a criminal trial. A conviction would be one. Untruthfulness would be another one in the Brady list. And what it means is this, is that every time you testify in court, if you're in a civil case or a criminal case, the district attorney or the city attorney would advise the court that in your background is an issue of concern. The example for the sheriff, if he stayed. If there was an issue of domestic violence, they would step forward, I believe, and say that this case you need to look at to help you make your decision as you judge the testimony of the sheriff.
Excuse me, in that sentence, who is you when you're saying this is an issue that you need to look at? Who are you referring to?
It would be the district attorney talking to the courts. They're required to notify them, so there's disclosure. And that never goes away.
If this is an acceptable question, wouldn't that be rebuttable or distinguishable if the person I understand that that's a flag, but could that be rebutted by being clear in the testimony or demonstrating that one was not testifying falsely or so forth?
Yes, sir. They would have a chance in court to rebut it, but the defense would be required to know about it before the trial starts.
Okay. I have just a few more questions.
Okay.
You have raised you have suggested that a law enforcement officer you have raised some questions about Sheriff Mirkarimi's discovery activities, the defense that he was mounting as a criminal defendant. And I wonder if you could help us understand how an individual who has certain rights in any criminal proceeding can mount a legal defense on his own behalf and continue to meet the standard of conduct to, as you described it, to support and cooperate with the administration of justice. I think that's one of the challenging dilemmas that we have to review.
Absolutely. Everybody has the right to attorney and representation and make the decisions on how they want to manage that case as it proceeds through the courts. That's something that's guaranteed to them. If they're not guilty, there's still an internal issue to take place, but it doesn't refrain them from doing that. My issue was this, is that there is some requirement, and it was with the guns, to step forward, and if they're required or at least asked for, they got a subpoena to do it, they should come and respond and give those up. It's evidence that they're asking for as a court order.
So your concern is not with mounting a defense or explaining what your behavior was or not agreeing to 4 charges but pleading to a single charge. It was specific things that you understood demanded a response like the subpoena, like the request to come forward with the guns. You also commented about a law enforcement officer's criticism or expression of lack of confidence in the criminal justice system. And I wonder if you could do the same thing. Help us reconcile the abilities both of free speech and criticism, public statements of one's belief with the responsibility to meet a law enforcement officer's standard of conduct, as you understood it in this situation.
I think we need to be professional at all times as a chief law enforcement person. I believe this, that, and it's not just my belief, but the other chiefs that I deal with, is that you have a right of freedom of speech, but to attack the system if it's unwarranted, if all they're doing is their job, is misconduct on their part and unprofessional.
And finally, you spoke about the affirmative duty of a law enforcement officer to ensure the integrity of investigations and to treat legal proceedings, including those for domestic violence, with appropriate gravity. I wonder if you could just explain to us what you meant about that affirmative duty and treating charges with gravity.
Yeah, understanding that the process, your responsibility to be professional, and understanding that committing a crime on the part of law enforcement personnel is a very serious matter, and that you need to manage that effectively and well, but within the confines of what the law says you can do. There becomes a point, I believe, where you begin to attack the system instead of dealing with the issue or the problem. And the problem is the defense. And defense should be managed well and effectively.
Thank you very much. I appreciate it.
Other questions for Mr. Chief Lansdowne? Commissioner Rennie.
Good afternoon, Chief.
Good afternoon, sir.
Following up on the questions about paragraph 58, it is on page 17 about the risk management, and you talked about Brady requirements.
Oh, yes.
That would only apply if the sheriff himself were personally going to be a witness in the matter, isn't that correct?
That's correct.
There. And how does the fact that the sheriff in this case has been convicted of a misdemeanor, how does that affect the ability of any of the sheriff personnel appearing as witnesses in cases?
Oh, it doesn't. It would only be when the sheriff is the one that's going to testify.
Did you take into account in forming your opinions the fact that Sheriff Mirkarimi was elected rather than appointed?
Yes, sir, I did.
And what effect, if any, does that have on your opinions?
It's my belief that the standard of behavior, the ethics, the integrity, the trust is exactly the same, whether you're the sheriff or you're a police chief, elected or appointed.
So that that you don't think a factor to be taken into account in the, say, suspension or removal of an elected official is any different than would be true of an appointed official?
The only difference that I would see, in some counties they don't have the ability to remove somebody other than a recall in the process. But the standard, this ethical conduct, this integrity, being the same person on duty as you are off duty, this trust that we talk about, sir, is exactly the same. You're the head law enforcement person, the sheriff of a county.
Thank you.
Any other questions for Chief Lansdowne? I have some questions, sir. I want to go back to your testimony about what you believe the sheriff affirmatively needed to do with respect to the press and media attention that Ms. Madison was receiving. So I want to give you a hypothetical since you're an expert.
Yes, sir.
If the sheriff did not tell the press to harass Ms. Madison, is it your opinion that we should find official misconduct because he didn't take affirmative steps to protect her from such harassment?
I don't think this case is complex, and I know we're all looking at it.
I just want an answer to my question. So,
on that and that alone, the answer is no.
If the sheriff had put pressure on reporters, let's say, to call Ms. Madison with story ideas, and the sheriff then failed to stop those reporters, the question in and of itself is getting complex. Let me try again. If the sheriff told reporters to call Ms. Madison with story ideas, and the press did so, is that official misconduct by the sheriff?
No.
So what then should the sheriff have done to, what should he have prevented, in your opinion, and why does that amount to official misconduct?
It's my opinion, sir, as an expert, that he should have stepped forward and said he appreciates Ms. Madison stepping forward, and thank you.
So it's his failure to do that that you think constitutes official misconduct, among other things, but his failure to step up and say, to commend her for stepping up is, in your mind, official misconduct.
I thought he should have defended her, yes, sir.
So yes, it is official misconduct.
Yes, sir.
And as you can tell from the questions from the commissioners, we're struggling with this notion of what official misconduct really is and how it relates to the duties. And so in probing that, what wrongful conduct could a sheriff engage in that in your mind is not official misconduct?
Not to be arrested for a crime, not to commit domestic violence.
You know, I'm talking about wrongful conduct that in your mind does not constitute official misconduct. Or do you understand my question?
I'm trying to understand it.
Let me try again.
Yeah.
Commissioner, I'm sorry. It may be easier for this expert, given the nature of his expertise, not to try and answer the legal question about what is official misconduct, but maybe to testify about the question he's here to testify about, which is the standard of conduct for a law enforcement officer.
It's a good point, and I'm going there. Thank you.
Thank you.
So what wrongful conduct could a sheriff engage in that, in your mind, doesn't relate to his duties as sheriff?
Well, I think all wrongful conduct would be problematic, but the issue of whether or not it meets the criteria that you're asking, if it's official misconduct, I'm not
Well,
sure.
that's not my, I rephrased because your counsel had a good point. What we're trying to figure out is, does the wrongful conduct relate to the duties? And what I'm hearing from your testimony is that basically any wrongful conduct in your mind by a sheriff is going to relate to his duties because of how wide-ranging his responsibilities are.
Oh, I see what you're saying.
Is that your testimony, or is there, in your mind, wrongful conduct that would not relate to the sheriff's duties?
No, I think wrongful conduct damages the reputation of the organization that you represent and the position that you hold.
Do you have...
You go. Finish yours.
Okay. I think that clarifies some of my questions. Any other questions from the commissioners? Do council have any questions in light of the questions from the commissioners?
No.
No, sir.
Okay, I think we should excuse Chief Lansdowne. Thank you for your time, sir.
Thank you for inviting me.
I was thinking that maybe there's in his mind that any conduct that's not disrespect or doing something in your church.
Okay, so that concludes the scheduled witnesses we had today.
He can make his point. That's what he's letting.
I think there is some additional business we should conduct. Do the parties have anything they'd like to raise?
I think we already have our schedule established.
Do you have anything to report on Ms. Lopez and the mayor's office's willingness or unwillingness to pay for her travel?
I don't, Commissioner. This is something I just haven't had a chance to consult with the mayor on yet.
Okay, when do you think you'll be able to know that?
I'll need to see if he's available this afternoon. I think with the earlier disturbance, I don't know how that's affected things. So, but I certainly can. If I can't reach him this afternoon, I'll make efforts to get in touch with him early next week.
That would be helpful, I think. Obviously, Ms. Lopez's, how she testifies is going to affect many logistics, so it would be helpful to know that sooner rather than later.
And if it turns out that we want to pursue the remote testimony route, do we have permission to just contact staff directly to talk about facilitating that?
You do, and I would actually ask if Ms. Canny is willing to also be available for that sort of consultation.
Yes, Commissioner, and I'll get that fixed declaration in by Monday.
Thank you. One thing that is looming on the horizon for us as we get through this testimony is how, as a practical matter, a 5-member commission is going to rule on findings of fact. We are not in a position to receive a list of 200 proposed findings of fact and rule on each one. You can imagine that would just be impractical. So I welcome proposals from the parties on how to deal with that. I have some ideas myself, but I'd love to hear yours, if you have any.
We'll just try to keep it short. I mean, I think it's hard to say that we only need 30 findings, we only need 10. I think knowing what pressure the commission is under, I think we would probably state the commission's ultimate factual conclusions that we would propose, and then the supporting evidence that would support those ultimate factual conclusions, just to keep it as brief as possible with regard to the factual findings.
Mr. Kopp.
I think the commission could vote on each one of the counts. I mean, I guess I'm unpersuaded by the need to make findings of fact. I mean, the way that I see
that's one of the jobs that we have under the charter. So
Well,
we've got to make findings of fact.
But it doesn't say Does it say in there that you have to make findings of fact? I think it says you have to make a recommendation. And
Assemble a record? What's the phrase?
Assemb-
Mr. Emblich, what's the phrase?
To
Right.
transmit
We
the
have
full
two
record.
jobs.
Yeah.
and make a recommendation. And
Okay, one at a time.
oh, I'm sorry.
We'll leave it to you.
You can transmit a full record to the board along with recommendations. However, you are the fact-finding body, not the Board of Supervisors, so presumably a part of that full record could be findings of fact.
Okay, I
I
stand
don't,
corrected.
presume that. I'm sorry to disagree with Mr. Emblich, but I think it could be done without this type of burdensome preparation and consideration. And I would just suggest that you vote on each one of the counts and make a recommendation. And I think that, well, I mean, I have my own ideas about what that recommendation could look like, but it's probably not the time to raise that. But I just don't see the need to do this kind of a process that might make sense in another tribunal when it's not mandated.
Here is one proposal. There are factual allegations in the charges, paragraphs 4 through 31. Upon reading them, it appears to me, and after seeing the mayor's case, which is now in, it doesn't seem like many of those are disputed. I think the ones that are likely disputed are the key facts that we need to adjudicate, and that will form the basis of any recommendation we make to the board. So what I would propose, Mr. Kopp, is that in the interim, while we have a few weeks before you put on your case, you let us know what paragraphs are in dispute and which are not. And that way, the commission, I think, could focus its resources on adjudicating the facts that truly are in dispute, and then applying them to the charges that are at issue. Now, I'm not saying that after you do that, we won't let you make some proposed findings or let the mayor make some proposed findings, but that might help narrow the issues now that you've seen the mayor's case.
And just so I'm clear, we would go through the amended written charges and identify those portions that are in dispute.
That are in dispute, exactly.
That sounds easier than the alternative. I'd be willing to try.
Ms. Kaiser, do you have any thoughts on that?
I agree that findings of fact actually are going to be necessary if there's any likelihood at all that the sheriff will pursue an administrative writ of mandate. The court, if it's going to review this procedure, is going to need to have findings of fact to look at in order to understand the basis of the decision. So I just wanted to point out that consequence that's a little further down the road.
Do the commissioners have any thoughts on the proposal with respect to the allegations?
Well, let me say I've been pondering this question about what our report is supposed to look like and what it's supposed to contain beyond the recommendations of either recommending that the board affirm the action of the mayor or take issue with that the position taken by the mayor. And I guess I would welcome suggestions of what the parties think that should look like. Because one of the difficulties I think that we have in the way in which we are required to operate in the Brown Act, it isn't like judges getting together or jurors getting together, or whatever it is, and talking among themselves and trying to come up with a document or a decision, because we have to do everything in public. And we need to have something, at least I feel, I need to have something substantial in front of me to say, yeah, this is a form that looks like the way in which I would like to try and resolve the problem. But I have a totally open mind as to what that document should look like. And I would love to get the suggestions from the parties and assistance as to what you think would be the most effective document which would comply with what we are required to do, and that is to prepare a record to send it to the Board of Supervisors with our recommendation. What that record is besides the transcript and the documents and the evidence that has come in, I really I'm not at a point where I say I've got, I'm not as I guess, as firm as the chairman about that it's got to be findings of fact and conclusions of law or something like that. Maybe that's what it's got to be. That certainly is the traditional way that one would proceed, but I'm open to any suggestion that makes some sense.
Mr. Embledge.
I would just say I agree the charter does not make your job easy because it doesn't give a lot of guidance on this point. It simply says make recommendations. I would urge the commission and certainly for the parties to weigh in on this at the appropriate time to consider two things. One is if the Board of Supervisors simply receives a recommendation that charges be sustained or charges not be sustained, the Board of Supervisors might wonder, well, how did they reach that recommendation? And since this is somewhat like an administrative law procedure where you are sitting as the hearing officer to provide recommendations to the ultimate decision maker, the typical model in that type of procedure, which I acknowledge does not fit this 100%, but that would involve findings of fact and conclusions of law to aid the ultimate decision maker in making their decision. That's all I can offer at this point.
Yeah, I appreciate that comment because I have no experience on the administrative side. All of my practice has always been in the judicial side, and I'm comfortable with that area. And if those in the city attorney's office who are familiar with what reports look like coming out of an administrative agency, which you might say is performing the same kind of function that we are expected to perform under the charter, that'd be very helpful to me.
I would also like to raise, if it's appropriate now, that it seems like there are more
I'm sorry, Ms. Kaiser. We'll give you that opportunity, but do you have a response to Mr. Rennie's question?
Oh, yes. I mean, we are very happy to provide samples. I'm sure that your counsel is also in a position to do that. I know he's very knowledgeable about these issues and these procedures.
Mr. Embledge, is there typically, in addition to findings of fact and conclusions of law, any sort of report or opinion that is issued in an administrative proceeding like this?
Well, I won't say that there's one, a uniform model. But in my experience, and I can provide some examples to the commission, that it is essentially a written advisory opinion that I have seen where, for example, someone seeking an administrative hearing about retirement benefits. The retirement board appoints a hearing officer. The hearing officer conducts hearings, takes evidence, and then provides a written, what we might be more familiar with, something that looks like an opinion from a judge that says, here are my conclusions. That's not the final decision. It then goes back to the retirement board for the retirement board to make the final decision. But it reads very much like almost a judicial opinion.
Okay.
I think a helpful analogy is a magistrate judge doing the initial work and making a recommendation to a district judge, for those who have spent time in the judicial branch.
Okay. Mr. Kopp, if your side is agreeable, I do think it would be helpful, at least in this first instance, to narrow down what really is in dispute based on the allegations and the charges. I do think we need to make findings of fact and conclusions of law the form we can continue to discuss and explore. When do you think you'd be able to provide the commission with that, just identifying the portions of the allegations that you dispute?
Before the next meeting. I don't know how much before that you would want them. If it's like the other document we're going to submit to you, presumably a couple of days before. So I think we commit to that.
Okay. Why don't we keep the same date? I think it was July 17th.
Yes.
Acceptable? Okay.
May I bring up that related issue
Sure.
that I think fits in? Because I do believe that in addition to considering facts and disputes of fact, there are also disputes of law here. And I'm wondering if there's a mechanism that can be put in place or that the commission can start to consider for getting more information from the parties about questions of law that are certainly and clearly, just listening to the commissioners, unsettled.
We definitely need that. And
Unsettled
I will say, I think, speaking for myself, that obviously the most pressing one is whether the or conduct that falls below the standard portion of 15.105E, whether that has to be in relation to the duties of the office or not. I think there are probably other legal questions that the commissioners have and that you may want to brief. If you want to brief them now in the interim while we have some time, we welcome that.
I'm sorry to interject, but from our perspective, these issues have been briefed. I mean, we were in the Superior Court, and then we filed our opening briefs. I don't know what there is to add to those briefs. And we can do a nice cut and paste job, but I think you're going to wind up seeing the same information.
Can I ask a question?
Sure.
This is a question for Ms. Kaiser or Mr. Keith. Do you agree that that second prong, the decency prong, has to be in relation to the office? Because for some reason I was thinking that when we had heard briefing on it in the prior sessions, that there was some kind of agreement from your office that it had to relate to his office and that you were trying to put on a case that showed evidence that it did relate to his office.
I actually think that there are a couple of points of legal significance here. One is, and this is not clear, I don't think, yet, what does the duties of office mean? Right? Is it just the things spelled out in the charter? Is it the charter plus statutes? Is it the charter plus the statutes plus what the San Francisco Sheriff says? You know, how do you define the duties of office for purposes of this definition?
But setting that aside.
Well, yes, okay, setting that aside, it is not our position that the second clause has to relate to the duties of office, however that ends up being decided. It's our position that the second clause relates to the professional standards of the office, which is something somewhat different than the actual duties of office, because professional standards are something you must meet as you fill that position, not necessarily just when you're doing some particular charter duty. So we believe they both have to relate to the office, but only one, in our view, has to relate to the duties, whatever that is, and the other one relates to the standard of conduct for persons holding that office.
Okay, thank you.
Okay, perhaps the thing to do then, before we make these findings of fact and conclusions of law, I think we're going to have another session after the sheriff puts in his testimony, his case. Does that seem to make sense, or do any of you see a way that we could resolve that without an additional session?
A session for the purpose of argument and briefing and facts, or?
That's what I was envisioning.
Yes, I don't see how you can avoid it.
Mr. Kopp?
Reluctantly, I agree.
Okay, so we can talk about scheduling and really figure out an end date to this if we can. Ms. Lopez, I've heard, is available on the 18th and 19th, whether she appears remotely or whether we bring her here. Clearly, having her here would be preferable, but I understand the limitations. Ms. Haynes, she can be here on the 18th and 19th, or 19th?
Yes.
Okay.
I'm sorry, do we know which of those dates yet?
Can both people commit to the 18th?
As far as I know.
That's what I've been hearing.
18th is Tuesday.
Wednesday, I believe.
Wednesday.
18th
It's
is
a Wednesday.
Wednesday.
It's a Wednesday.
I apologize.
That's okay. Just that one.
Okay, so then I'm hearing that Ms. Haynes is available to testify on July 18th in person.
I haven't heard directly from her lawyer, so I'm relying on what Mr. Kopp knows.
July 18th, Ms. Haynes can testify.
That's my understanding, yes.
Okay, so we'll have her on the 18th. Ms. Canny said that Ms. Lopez can be available on either the 18th or 19th, so let's just put it in for the 18th. I think that's a good idea.
Both?
Both. Is Mr. Hennessy going to appear live?
Not as far as I know.
Okay, so then there are 2 witnesses remaining, and they will both go on July 18th. Any objection to that?
Commissioner, no objection on that, but we need to sit down and go over Sheriff Mirkarimi's testimony to determine if we feel that we need any rebuttal witnesses. I simply don't know if we do, but I feel like we need to alert the commission that we might, and certainly it's something we'll look into as quickly as we can, so that we can get back to the
everybody
commission.
hold the 19th. Okay, do not release the 19th. I would like to know by July 6th. Is that doable? That's next Friday. Or we can do the 10th if
I
you have a
think
real problem.
we might be able to identify the witnesses by July 6th, certainly. We could certainly identify them by July 6th. I don't know if there are going to be any. A part of it depends on how quickly the court reporter may be able to get us a transcript.
Let's do it. Let's do it July 10th.
Okay.
Let us know by July 10th whether you have a rebuttal case or you want to present a rebuttal case. Is that reasonable?
Yes.
Okay.
Well, 2 issues, actually. One is we would like to have some dates certain by which we will know with sort of definiteness whether or not Sheriff Hennessy is going to appear on the 18th.
It sounds like he's not appearing.
Is that a commitment?
That's the status right now, as far as I know. If he changes his mind, I'll let everyone know in short order. I mean, I'm...
Okay, if we don't hear from you by July 10th on that, I think we should exclude him.
That's fine.
Okay.
Thank you.
Okay, so then after the 19th, I presume that you will want some time to get us, by citation, the evidence that supports whatever facts are actually in dispute. And at the same time, I would be willing to provide the parties with an opportunity to brief whatever legal issues they think that need to be briefed. If you don't think they need to be briefed, you don't have to submit them, but I'll give you the chance. I think we should give you the chance to do it if you'd like. How much time would you need to accomplish those 2 tasks? Fact in the left column, supporting evidence in the right column.
Yeah, you.
Oh, just...
And the brief on the legal issues.
On the what issues?
Legal issues.
3 weeks would be beautiful, but let's, I think 2's more likely. I'm sorry. One thing that goes into this is in terms of the rebuttal witnesses. Are you going to ask us to proceed by declaration again, or would it just be a matter of bringing people in for live testimony, and one's faster than the other at this point?
Yeah, I think we may just go to live testimony for rebuttal witnesses.
Okay, thank you.
If any.
If any, yes.
So then timing-wise, how much do you need to, after the 19th, to get us?
I would think at least a couple of weeks, because that testimony will have to be digested and included. So I would think a minimum of 2 weeks.
I think
We prefer 3. I would propose August 10th.
I mean, I think honestly we'd like more time, but I think we also just want to get this in. So 3 weeks we could do.
I am going to, it's Mr. Kopp's client for whom the time I think is most pressing. So, Mr. Kopp, if that's agreeable to you, we'll go with yes.
What date?
August 10th.
August 10th.
I'm unavailable between the 8th and the 13th.
This would just be for when the papers would come in,
okay.
not the meeting.
All right.
It's also my understanding that the board is out of session for, no?
No, but that won't
matter.
trigger our submission of the record is what triggers the board's involvement.
I'm sorry, I can't hear you.
Our submission of the record is what triggers the board's involvement and board's deadline.
And you're intending to submit it while the board is out of session?
No.
That's why I was mentioning it, that there's a
Ms.
period
Kaiser,
when the board
we'll
is
get
out
to
of
that.
session.
I'm cognizant of when the board is gone. I really
Thank
just
you.
want to get this scheduled.
And, our concerns for expediency have been diminished by the fact that we can now see that it's really not going to conclude that quickly. So we're happy to extend 3 weeks, 4 weeks to them if that's what they need.
Okay, well, I'm asking what you want.
I think a minimum of 3 weeks is what's
Okay, so
called
the
for.
10th, August 10th, to get that in?
It's fine.
Then my thought is that after having those, at the next meeting of the commission, whenever we can schedule that, we would come to a conclusion. We would deliberate on the findings of fact and propose conclusions of law, and we would make recommendations on whether there was official misconduct or not. At that hearing, I would be willing to entertain some short closing argument if you all wanted to do it. It'll have been a little while since we've heard the testimony, so if you would prefer that, I think I'd be willing to entertain it.
I'd prefer it to voluminous briefing, but I would agree that it ought not to be a long argument.
Okay, well, it's not going to replace your specifically identifying for me where in the record you think, the evidence lies. But if you want to do a closing, I could see it potentially being helpful.
Can I reserve my recommendation on that till we meet next time?
Sure.
Thank you.
I'm concerned that I may have aided in Commissioner Rennie's proposal of that the parties make suggestions about how the decision look or how to help the commission. I don't know if that's something that you still also wanted from the parties. And I don't want to have brought tension away from that by accident.
I'm not sure I follow. If you have an additional recommendation for how the papers should look, we can talk about it, I suppose, on the 18th. But I'm just telling you when we want whatever those papers are, when we want them. And so August 10th, we'll have your conclusions of law and findings of fact on August 10th. So now the next question is when should we meet to discuss this? What is the commission's availability the second full week of August?
Dandy.
Dandy, says Commissioner Stubbs.
The week of the 12th.
The week of the, yes.
The
So
6th or the
12th, the 13th, that week. So it sounded like Commissioner Rennie was not available on the 13th.
Are we talking July or
August.
August. As far as I know, I'm available.
I apologize. My phone totally died, so I don't have my calendar, but I think I'm available
That week?
that week. Yeah.
Well, we can hold a couple dates and then see
Okay.
what works. What about the parties?
That second full week, beginning with the 13th?
Not the 13th, but the 14th through the 17th.
The early in the week is better for me. The 14th, that would be a preference. I just have a commitment later that week.
Is it avoidable? Because we won't have that much time to,
Okay.
well, let's see what's available.
I'm not available on the 17th.
Okay.
We're talking day or night?
14th or 15th. The 14th or 15th would be preferable for us, either of those dates.
I'm sorry, we're trying to
Okay.
figure out if this works.
Ben,
Yes.
what date is our regularly scheduled August meeting?
A regularly scheduled August meeting, I believe, is the 27th
27th, okay.
27.
Okay.
of August.
It looks like that week, from the 14th through the 17th works.
I'm just going to show you.
The last 2 weeks of August, I know, are not very good for us.
We got to get done by then. Agree. I'm sorry, Mr. Kopp, you said,
I think that week of the 14th through the 17th is okay, but after that, the rest of August is problematic.
okay, well then, let's schedule it then. And are you talking about daytime availability? Because one thing I'm thinking is if we can do it during the day, we do it during the day so that we make sure we get it done.
We'll do it during the day if need be.
Okay. Commissioner,
If it's during the day, I do have a couple hearings. I have to look and see exactly what dates. I have hearings in August I need to check on, if it's during the day.
I have a phone charger I've been using if it's an iPhone.
It's a phone that I've been having problems with, so I think it's going to take forever to charge if I do it right now. Thank you, though.
okay, so why don't we, do the parties have any unavailability from the 14th to the 16th? Days that absolutely things cannot be moved?
No.
Okay. If you could hold those, why don't we plan to talk on Monday? I'll talk to the parties just about scheduling. In the meantime, we can get Commissioner Liu's calendar and figure out exactly when in that period we'll be able to have our, I'm hopeful, last meeting on this.
Thank you.
Any comments from the commissioners or objections from the parties about the schedule we've discussed?
No.
Neither one of us is available to consult with you on Monday
But,
Okay, we can do it
okay.
Tuesday.
or Tuesday.
Well, we can work. We can
Okay,
work.
we'll
we can
figure
work
it out.
We can work out a
Usually
time when one
those
of us
are-
can
yeah,
be available.
Okay, great.
What time are we scheduled to start on July 18th and July 19th?
July 18th and 19th are evening sessions, I believe. We haven't set a time. That's a good idea. We probably should. Why don't we plan to start at 5 o'clock? Are the rooms available at that time?
I don't have a calendar with me. Is the 19th is a Thursday, I take it? Many times the room may be taken until 4:30, 5 o'clock. So perhaps on the Thursday, if you can start at, at 5:30.
Okay, well, why don't we do this? We'll send out the notice, or you can contact Mr. Embledge or Ms. Ng like you have by CCing other counsel, and we'll get that figured out. But reserve the evening, the 18th and the 19th.
If it's possible, I would request, when we're hearing witness testimony, to be in this room again. It works out very much better for council, I think, and hopefully for the commission as well. I know it's limited by availability.
Yeah, I agree with you. This room is much better and much cooler as well.
Also.
But the rooms apparently are very hard to come by, and so we'll do our best.
Thank you.
Anything else? Okay, as is our practice, I recommend that we take a vote regarding the rulings that the commission has made today. Is there a motion to approve on an interim basis the rulings that the commission made today?
So moved.
Is there a second? Second. All in favor?
Aye.
Opposed? Okay, the meeting is adjourned.